everyone. We're going to be starting here soon. Just want to switch over to our audio check. So just let everybody know you should be able to hear us. Tom, do I get the thumbs up from you? Is all good? Colm, Ian, you can hear me? Great. Stacy is,
Yeah.
thank you, Stacy. I appreciate that. So fantastic. So I want to welcome everybody, and especially everyone in Cayman who is under you're not a hurricane watch, but a tropical storm watch. So very committed people in Cayman. So thank you for joining us, especially those of you who might have kids in the background as schools are closed. We do have two wonderful speakers. We're welcoming back Colm Dawson, and he spoke on the beneficial ownership. Welcome back, Colm. And we also have with us Ian Mason. Both are with Walkers in the Cayman Islands. And for those of you who are joining us for the very first time, I wanted to welcome you. This is a free webinar series where we have different guests, and we would just kind of discuss and share different topics with various experts like Colm and Ian. So again, thank you very much. A little bit of housekeeping before we begin. So this webinar is just for training and informational purposes only. It is not deemed legal advice. It lasts about 1 hour. We do try very hard to keep it at that. There will be a certificate of attendance that will be automatically generated for attendees of the live broadcast only. So if you're here today, you will get that. And that goes out about 1 hour after the webinar ends. We will take some questions at the end. There are quite a few, several hundred people joining today. So obviously we can't get to all the questions, but we do try to get to what we can. And please just use the question box if you have any comments as well. There will be 4 polling questions, so we'll start with a couple of those. And also, because I do realize a lot of you sometimes have to jump off, so I just wanted to say we do have some upcoming events. One is practical uses of ChatGPT and compliance. That is this Thursday. So you will get a registration link for that if you'd like to join us. We've got a certified silo user training programs series that starts 13th of November. And then on the 27th of November, it will be our very last AML Gray Matters webinar for 2024. And that is going to be on Interpol abuses. So again, just stay on or keep an eye out for those emails as they come out. So our presenters again, Colm, and sorry, I didn't change the slide. It's actually Ian, not Andrew. And guys, I am going to let you take it from here. So again, welcome and thank you very much.
Thank you very much, Kimberly. And I am Ian. I can only aspire to be Andrew Houth, obviously, but it's Ian Mason here for today. So hello, everyone, and thank you for joining us today, particularly what's also going to be a very interesting day in terms of the US elections and the kind of weather forecast on Cayman. So thank you very much. And Colm and I are both broadcasting from our respective homes. And if you hear any meowing or cat noises coming from my microphone, then that's my cats trying to join in, which they quite like to do on these sorts of calls. So we're delighted to talk to you today about SEMA inspections and also responding to DITC enforcement action. We're planning to cover the typical stages of a SEMA inspection, some practical points along the way, as well as the areas that SEMA tends to focus on based on their own feedback from inspections and on our experience. So we go through to the next slide.
Are on the agenda. Tom, do you want to start the first polling question so we can kind of get an idea of our audience? Yeah. So
Awesome.
yes, our first
poll is launched.
Okay, great. So yes, have you or your organization recently, within the past 5 years, undergone a regulatory inspection? So this is looking very interesting. And of course, I did set it out that yes, your firm has, and you are the point of contact, or you're in senior management, so somehow you were involved. Or yes, you're aware that the firm did go through an inspection, but maybe you were not as involved. And of course, the other answer is no. So, okay, quite a few of you have gone through a regulatory inspection. So we are showing just over 40%. Thank you, Tom. that have undergone an inspection. 30% their companies have, but they were not involved, and about 27% is no. Great, thank you. You can go ahead and close that poll. And one more before we get started. And how prepared do you think your organization is to handle a regulatory inspection? So the options are very prepared, somewhat prepared, neutral, and not very prepared. All right, we are looking very prepared, about 35%, 36%, somewhat prepared, 46%. So that's probably why most of you are here, to see how you can fine tune that. Neutral, 11%, and not very prepared, 5%. So I hope we can really help out that 5%. Great.
Absolutely, and our email addresses are at the back of the slides as well, particularly for that portion. Hopefully this can equip you with some useful tips to move out of that category. But
Yeah.
we are very much happy to help for anybody that needs any assistance.
Okay. Thank you. So Tom, you can close that poll. And again, I will mute and we'll move on. Okay.
And next slide. Yeah, so I think that's a nice segue actually into this next slide, which is why do inspections matter? And as you've seen, CIMA is undertaking an increasing number of inspections. So at some point, you may well face one if you're a regulated entity, a financial services provider, and CIMA will very likely find some issues to raise, and that may result in an inspected firm having to fix or remediate those issues. And in most cases, the firm will be able to take remedial action itself, but sometimes you may need to involve an independent advisor, such as a compliance consultant or a law firm like ourselves, to oversee or to advise on or to oversee the remediation and check that it's been properly implemented. For example, an independent audit report, that's something that we see sometimes. And in a few cases, inspections can result in a public enforcement action and fines. So as well as the actual fine, there's also the adverse publicity. So really, this is something that you don't want and want to avoid. So be prepared. Next slide, please.
And Ian, maybe if I can just chime in at that point
Yes.
as well. I think
Okay.
the practical implications of the enforcement, as Ian had said, the reputational damage, something that we see quite often is that it would occur as part of the wider business. So I know that there are a lot of people who are actually based and operating from the Cayman Islands on the call, but for any international entities, they're generally in DDQ exercises, very broad ranging queries and questions about whether or not you've ever been involved in an enforcement action. And so that means that regardless of what part or geography of the world you're operating in, you may need to provide responses in the affirmative to the extent you have been involved. And so managing the process and being prepared is probably the biggest takeaway that we can give you for the entire session. So, and drilling into the details, I think based on the last available information, we had ascertained that approximately 11 was the number of matters requiring attention in the CIMA reports for registered persons or other types of entities that were registered or licensed. And I think all bar one did require an independent audit as a closeout step for that purpose. So the audit planning process is something that should be stitched in right from the beginning as part of your preparations.
Thanks, Colm. So yeah, there are various stages of a CIMA inspection. So there's the pre-inspection preparation, and that can be key. There's the inspection itself, and then the report phase, preparation of the report, and then responding to the report. And we'll look at each of those stages in turn. I'll just pause there.
Yeah, and I think it's important to consider each of those phases. And also, actually, again, we are primarily practicing the laws of the Cayman Islands. And so, in the experience with the CIMA inspections team, there can be a CIMA direct team that conducts it, or indeed, in certain circumstances, there can be an external party that's conducting it on behalf of the authority. The timeframes tend to run fairly similarly depending on which is appointed, but there is a difference in terms of the engagement and the field work that's executed. The authority are responsible for the reports at all stages and are kept on correspondence, but the actual fieldwork component, when you essentially receive the list of requirements that are being procured, that can actually be then directed towards a third party on behalf of the authority, who become your ongoing participants for to narrow the issues before it gets back to the authority for the final report.
Okay. Tom, we have another poll question. You mind launching that, please? Okay. How often does your firm conduct internal or mock inspections to prepare for SEMA oversight? All right, this is going to be very interesting. I have never actually participated in one of these. I thought this is a great question. All right, looks like quite a few of you have never participated. All right, and let me ask you guys this. Who would be the staff who are to be prepared, with these mock inspections?
Yeah, I mean, they'll tend to want to interview one or more of senior management, so they'll be interviewing senior management, and also typically with the money laundering or compliance team as well, officers. So where we've been involved, we've typically helped those those group of people to prepare basically, and actually kind of conducted mock interviews and sort of thought about the sort of questions they may get asked. And certainly I think they found it very helpful when the real thing comes along.
Okay, fantastic.
Yeah.
Well, go
Sorry,
ahead,
Kim,
Paul.
I might just add in as well. It is possible during the inspection process that we can attend as observers, stroke note takers when the inspection process is ongoing. So we actually do have pretty good insight as to the type of questions that come up. And in preparing for any of these engagements, again, it's the being organized and being able to describe cogently the type of business in which you're involved and the client population, etc., is extremely important. It will also depend on the type of entity that's under review as to who needs to be concerned with these items, because obviously the second line of defense, the compliance teams, are going to be centrally involved in living it day to day, but it is actually the operator of the entities. So as Ian has said, senior management that don't necessarily need to know about the nitty gritty as to, for this particular type of customer, we need to get these 4 documents. But at the same time, there needs to be at least an oversight and awareness of the types of control mechanisms that are in place. Particularly, I think it's fair to say in respect of financial crime issues traditionally, but as the statements of guidance on corporate governance and internal controls have now kicked in, it's also very important to be aware of the requirements for regulated entities and supervised entities in that regard.
Okay, thank you. So our responses so far: annually, 21%, semi-annually, 5%, quarterly, 6%, rarely, 30%, never, 36%. Is that what you would have expected?
I mean, it's kind of hard to say, really. I mean, those in the kind of rarely or never category might want to consider
I think it's
having a mock inspection.
yeah,
Yeah.
I think it's fair to say that we've probably all been involved in engagements on whatever side of the table, people that are sitting here as participants on the panel versus people that are actually in the audience. They will have been involved in situations where it's very clear from the outset that there has been very little or no preparation. And I think in terms of setting the tone, and Ian can speak very, very, very authoritatively on this, having been the head of enforcement, it becomes very apparent very quickly whether preparation has taken place or not, whether that's preparation a week in advance, having received the letter and then engaging legal counsel or compliance consultant, or whether it is the types of robust annual exercises that you can point to that 23% of the participants have said do take place. So I think the preparatory work will put you in good stead, apart from anything else, being able to respond to the request for information within usually what is a week or 10 days type time frame to produce the information, because even being organized at that level can demonstrate you're on top of the process even before your first meeting.
Right, right. And we had mentioned earlier too, it's almost like this should be a little, especially given the size of fines these days, to consider this part of your disaster planning program, because it will eventually happen, and very likely to happen. And so get your staff, or those who are going to be involved, very well trained and to know things. All right. Thank you, Tom. You can end that poll now.
Right, so next slide, looking at the pre-inspection process. So SEMA will kick off the inspection by sending the firm a notice of inspection, and do review the notice carefully to see what type of inspection it is. For example, is it a full scope inspection, which will review all the lines of business undertaken by the regulated entity, or is it, for example, an AML or a prudential inspection, or is it focused on a particular theme that SEMA is looking at? And the notice will be accompanied by a request for a long list of documents. Typically, this will include copies of various policies and procedures that relate to the area being examined. And there will be a fairly tight time to respond, typically 2 to 4 weeks. And it may be that some of those documents are not readily available. For example, they may be off-site, they may be archived. Hopefully they won't be if they're actually all compliance policies, but you kind of never know. So do bear that in mind if you need to request an extension. And once you send that documentation in, SEMA will carefully review the documentation that you've sent, and you may get another request for further documents or clarification shortly before the inspection. And you may also find at this stage that SEMA has appointed an external firm to assist with conducting the inspection, typically one of the accounting firms we've seen, but SEMA does retain overall responsibility for the inspection. So if it's outsourced, they are working under the instructions of SEMA, but obviously feeding back the outputs to SEMA. And there's an important point there. There is no timeline for the inspection. There's no finite timeline. It's fairly open-ended. So that's quite different actually to some other jurisdictions that you may be involved with. I don't know if you wanted to comment, Com.
No, I think that's pretty much covered everything comprehensively. I think there normally are 1 to 2 senior people from SEMA on the calls at even in the outsourced capacity if they're not actually conducting the field work themselves. And as Ian has said, they clearly are steering the inspection process, even if the field work is being done by a third party. Again, the point at the bottom, and I am probably going to be like an old record by the end of this, the information gathering and preparation phase is critically important to position just how prepared you are for this engagement. I have been involved in situations where there has maybe been 1 to 2 interactions with the authority already at the point in time when we were introduced. And in one case, for instance, a registered person may or may not have answered questions in the context of responding, but on behalf of a fund. And so being very, very clear about which entity is under inspection and being very clear about who the customers are of that entity is of critical importance. So it's not just being able to put your hands on the compliance policy, it's being able to appropriately respond to the request for information based on the entity that's actually under review is key.
Yeah, very good point. So yeah, if we go on to the next slide, please. Yeah, so this is really, I think, one of the key slides for the seminar, really about setting the right compliance tone. So it's really important to show SEMA that you're taking the inspection seriously, and you can make things a lot worse or a lot better, because if you respond badly to the inspection and you don't cooperate, or seem to think you're not cooperating, that's not going to go down very well. But if you show cooperation and project a kind of positive and collaborative tone, then that will, if SEMA do find issues later on, the fact that you have been cooperative and helpful will kind of help to mitigate that. And it's an opportunity in inspection to build a positive relationship with SEMA and show that you are cooperative and comply as fast as possible with their timelines in responding. And as was mentioned, I kind of have worked previously in enforcement as enforcement head at the UK FCA. And often people will say, well, look, why am I under inspection here? Why have I been stopped? Person down the road, firm down the road is a lot worse than me, and they're kind of carrying on with this. And why are you inspecting me? And the analogy I draw is kind of a bit like speeding, really. So if you get stopped for speeding by the police, then it's you that's been stopped. And there may be lots of sports cars driving past you, going much more quickly, but that's not who the police or the regulator is focusing on. They're focusing on you. So you've got to deal with it. And firms sometimes feel a sense of unfairness or injustice, that it's that firm that's under inspection or is kind of focusing on a breach, but that's unfortunately just the way of the world. But how you respond to that is really a key factor. Colm, did you want to say something at this point?
Yeah, I think that's a very good point, Ian. And the authority is under an obligation, given its role as the competent authority for many of the aspects in which we're advising, to ensure that there is a credible threat of enforcement as well. And so once you are in a position that you're under inspection, engaging with the process at the earliest possible point and allocating appropriate resources to deal with it is very important. It's not an adversarial process either. So as much as I love my litigation colleagues, this isn't that. It's not a court case, but there are iterative processes and exchanges of information. And if there are any disagreements as to fact, or if there are any disagreements as to the interpretations, those can be discussed, but it is not an adversarial forum in that sense. And Ian's feedback and experience in terms of engaging on the process, we have been fortunate enough that any of the inspections and engagements that we've been on have had, in certain circumstances, robust exchanges of views about the applicability or otherwise of measures. But at the same time, those are based on our interpretations of the law and guidance, and similarly, the authority has its positions on certain things. The ongoing and iterative process of the exchanges of information can resolve those points down to agreement points. Not all points will end in a full agreement, as I think anybody, the portion of you that have been through the inspections possibly might disagree with certain of the endpoints, but that is just part of the process. And ultimately, in discharging the statutory function, the authority has a very important role to protect the islands from any sort of reputational damage that could be arrived at by not having registered persons or other licensees that are not adhering to the standards that are put in place.
Yeah, and just looking at some of the other points on that slide, we think it is a good idea to nominate one point of contact for SEMA to communicate with. So they don't want to be dealing with lots of different people. They want to be able to deal with one person at the firm, preferably a senior person, a member of senior management, or a senior person in your compliance team or in your AML team. It is important anyway, as we said, that senior management are involved in the inspection to show that they are committed to compliance and corporate governance. And mock interviews, certainly our clients have found those very helpful in the past. I obviously, in enforcement at the UK regulator, used to be involved in doing fairly detailed investigative interviews, so I kind of know the tricks from that point of view, and generally the feedback has been very positive, so that when you face the actual interview, it's not quite so scary if you have been well prepared. And when preparing for those interviews, what is your nightmare question? What don't you want SEMA to ask? What are as a witness? I mean, kind of game those nightmare questions. What don't you want to be asked about? And prepare answers for those questions, because it's quite possible you may get asked those questions you don't want to be asked.
Yeah, and also in terms of the attendees at the sessions, it is also good courtesy, apart from anything else, if you are going to be introducing any third parties such as law firms, to request permission of the authority for those attendees to actually attend, even in a note-taking capacity rather than in a fully contributing capacity at the meetings or at the interviews, to make sure that that everybody is aware as to who is there and in what capacity they're acting. But I think Ian's question there is an excellent one about what is the exact question that you do not want to be asked, because that probably will push you into the thought process as to why that question is one that you might not want to be asked, and ultimately to bring about an appropriate endpoint for that situation, so that the next time that question isn't one that would be on that list.
Yeah, so going on to the actual inspection process itself, onto the next slide, please.
Okay, actually, I think we have one final poll question, Tom,
Okay.
if you can go. Have your staff been provided with specific training on what to expect during a CIMA inspection? So we are currently looking at, yes, recently. We've got about 15, 16%. Yes, but it's been a while. About 23%. No, but planning to, 35%. And no and no plans, 19%. All right. Thank you very much.
Okay, well, I think my comment to that would be, obviously, no, but planning to, would be very happy to talk to you. And the ones who have no plans, I can understand that if you're not facing an imminent inspection and you don't expect one to be on the horizon. But having said that, when they do come along, you will have to move very quickly, because often the timelines for responding, as we've said, on document requests are quite short. So you might want to bear that in mind if you have no plans at the moment.
Okay. I'm going to close that poll, Tom. There you go. Okay.
Okay. Yeah. So moving now on to the inspection itself. So typically there will be an opening meeting, and this is important, and we recommend this should be attended by sufficiently senior and knowledgeable staff at the regulated firm. And it's a good opportunity for you. It's a good opportunity for the firm to actually explain its business and any particular complexities or quirks that CIMA should be aware of. For example, you might have a group structure spread across a number of jurisdictions, and how does the Cayman entity fit into that? You have to bear in mind that, as we've said, CIMA are doing a lot of inspections, so it's not one size fits all. So it's very helpful to them if you take the time to explain to them your particular group structure, and if there's anything particularly unusual or important about your business that you want to communicate with CIMA, they will appreciate that, and it's in your interest as well, actually. And be prepared to answer any questions from CIMA at the opening meeting, which again is the reason for having people at the meeting who are sufficiently senior and knowledgeable about the firm. During the inspection phase, CIMA will arrange interviews with key personnel, as we've said, such as senior management and the AML officers, and as we said, prepare interviews for those interviews and arrange mock interviews. Something we've seen an increasing focus on is sanctions and sanctions monitoring. And as well as our actual sanctions procedures, we've certainly seen that CIMA might want a live demo of sanction screening. That's quite a popular CIMA request now experience. So be prepared for that. Colm, did you want to input here?
I think that's you've hit all the relevant points, and again, it's critical that there is some form of practice done in this area, because it's not that it's easy for us, but it's what we do on an ongoing basis. So having the correct messaging for the authority, which is based on the facts of your entity, is obviously critical. But that doesn't necessarily roll off the tongue if it's not what you're doing on a day-to-day basis. So being prepared and being able to give an equivalent of an elevator pitch as to what your entity does is very important, particularly because these can be international businesses with many different components and people wearing various different hats. So being very clear as to the entity being inspected again is something that I can't stress enough. But also the sanction screening point is very well made, and the persons who are charged with actually undertaking that work, or indeed the overlay on the outsourced service provider, is very important to have appropriately documented, and there being a very clear step plan as to how those controls are put in place is key.
Absolutely. So moving on to the learning the outcome of the inspection. So this, if you like, is the scores on the doors phase. So before you receive the draft inspection report, CIMA will send you a discrepancy list. And that's an indication of some issues that they have found. And it's a chance for you to clarify or correct something. So that's one good opportunity for you to kind of input at that stage and put over your comments and correct any factual inaccuracies.
Yeah.
And then there is the closing meeting, which obviously it's important that is attended by sufficiently senior people from the firm. And the firm will usually receive a draft inspection report after a couple of weeks. And again, it's a draft inspection report. So sometimes people say, oh, I've got to respond now, sort of thing, to all the points raised. But no, this is a draft inspection report. So you have the chance, again, an opportunity to respond to what's said here in the draft, make your management comments. CIMA will consider those, and then CIMA will issue the final report. And then usually the issues raised will divide into urgent issues requiring quick remediation on tight timelines, and then the less urgent ones. And then on average, CIMA tends to find, I think these are CIMA's own statistics, around 11 findings per inspection with 3 to 6 months to remediate. And CIMA will expect you to explain how you've addressed those issues, and they'll be ticking them off on the list. If you state to CIMA that you have addressed the issues, it's not a good look to actually then fail to implement them. So you get the issues, make sure you fix them, make sure you've told CIMA you fixed them, and make sure you have fixed them. Because if you haven't fixed them and CIMA come back, that's not great. That's an indication of a poor compliance culture and really senior management not taking things seriously.
Yeah, and just to chime in there as well, Ian, I think the role of the cover letter is important to consider in this regard too, because there can be some material that's addressed in the cover letter that doesn't find its way into the back of the inspection report. So it depends on the nature of the entity that we're working with, but in certain cases, it's that second to last page, I think it is, where there's the table of requirements that is the laser focus, rather than necessarily the management comments and responses. It's very interesting, and we're fortunate that we have a wide overview of the market and have been involved in quite a number of these processes, that certain clients are very, very keen to make sure that if there is an objection in principle, shall we say, based on a particular piece of legislation or guidance from CIMA, that there's just an outright disagreement that the control has been put in place, but the management of the entity is quite robustly asserting that they did not disagree with it. That can actually be recorded within the report as well. That would very much depend on client preference as to how strongly you wish to provide these management comments, rather than just flipping over to the second last page and essentially putting in place a remediation plan to address the issues. And the final report aspect, as I mentioned, almost invariably does have an independent audit validation exercise is included as a component. So at least there is a independent party that actually will be going through all of the issues that have been raised and essentially closing that out on an arm's length basis. So that is something that's usually stitched into the actual fabric of the report anyway, but is something it's a useful guide and aid for people that are under inspection to ensure that they are actually closing things out. But the types of issues that we see raised and the trends, I think, is actually covered off on the on the next slide in any case. But so I'll just leave my comments on that till you're finished, Ian.
Yeah, I think it's over to you now, Con.
Okay, very good. So the lessons from previous inspections, in particular CIMA areas of focus, the SEMA has published pretty widely on these and the ongoing trends, and there really isn't anything that's particularly surprising here because they form the meat of the obligations that most of the entities that I'm sure you guys are working in and the ones that we work with on an ongoing basis are there. So outsourcing is a key focus. Corporate governance, sanction screening, board governing bodies, performance assessments, business continuity, cybersecurity, records management, conflicts of interest declaration and management, succession planning, and complaints handling. The last one, actually, the complaints handling, is of particular interest considering there was a supervisory information point issued over the last couple of weeks clarifying what expectations are in this regard. And I think it's certainly the case that for persons that maybe have relocated to the islands from overseas, the areas around complaints handling and consumer interactions are different here than they are elsewhere. So it was interesting to see that point coming up. To be extremely honest, in my experience, the one that comes up the most for registered persons, many of which I would have worked with when I was sitting in the Walker's office in Hong Kong for 2.5 years, it's the customer due diligence process. So registered persons are quite frequent in that part of the world. And so the point that I've been stressing around delineating who your clients are and who your clients aren't and what the responsibilities are is critical, because those registered persons will often act for funds that are affiliate entities. But it's critical to understand that unless there's a beneficial ownership component, and I am running down a rabbit hole here, but if there aren't people that actually own the funds as beneficial owners, your clients are actually the funds in that context. So it's understanding and defining your customer population and building from there will mean that your customer due diligence process will be far more coherent on an ongoing basis. Apologies if there's any echoes in the background. It sounds like the rain is starting to arrive here in Georgetown. But other issues then that have become more front and center over the last time period in particular are in respect of the governance, outsourcing agreements and parties being appropriately due diligence before important functions are given to them on an outsourced basis are also very important. Cyber remains a key issue, particularly for entities with more complex business models. The systems and controls that are required to be put in place are critical. Records management. Ian made a very good point. You should be able to put your hands on any documents that you need very quickly. And the international nature of financial services and various competing data protection requirements and security parameters can mean that certain documents might not be as accessible as they should be. There are generally requirements to be in a position to produce information to the authority on an ongoing basis anyway. So this is a wider tip rather than being specifically limited to the conduct of inspections. But I think that is something that is very important. We have been working with a lot of clients on the corporate governance and internal controls measures and implementing appropriate approaches to those too. So I think it's fair to say that we're likely to see more engagement on these issues as the years go by. Registered persons were, of course, quite an area of focus for the authority, given the supervisory impact that they were deemed to have in the national risk assessment as well. So until there are other published priorities, and I think we all find those types of interactions from the SEMA teams extremely useful so that we can direct clients when there are publications around what the authority is looking at. I think everyone on this call should take note as to where these are coming from and then putting in place measures to address those issues or to at least consider them so that you are in a position to respond to any of the supervisory circulars and the other types of activity and engagement that don't quite come up to the mark of an inspection process. But it is important to engage on those when they are issued to industry. And then actually, I think I have the next slide as well. Um, the other body that we were going to speak to just quite briefly, given that this primarily is in respect of the licensees and registrants, is in respect of DITC enforcement action. I think given the couple of weeks that have been in it, it was important to reference this for any of you working with Cayman Islands entities, and particularly any of you that are working in registered office service providers or actually doing reporting for AUI purposes. There have been quite a number of breach notices issued over the last couple of weeks most specifically in respect failures to report nil returns or to otherwise complete CRS compliance forms. So that the Cayman Islands Tax Information Authority also is reaching out and conducting desk-based audits, which are quite similar in terms of the structure to the engagement that is required with CIMA. It's essentially a list of information required of a financial institution to validate the control environment that has been on. I was fortunate enough to attend the very useful Cayman Islands Compliance Association session yesterday with the DITC, who spoke about the overhaul of their enforcement process. And again, having a credible threat of enforcement is critical for all of the competent authorities that act in the islands to ensure that where parties are not doing what they're supposed to do as prescribed in law, that there is a downside to doing that, because I'm guessing the population on this call is all quite committed to ensuring that the jurisdiction is protected and from any reputational harm of being deemed harmful on the tax side or being deemed non-compliant on the FATF or other type of supervisory side of things. So it's important that where people don't actually have reasons for non-compliance, that there is certainly a penalty for those parties. So in previous years, we've seen data matching exercises between CIMA records and records where entities may have had GINs, the FACA numbers, and through the Internal Revenue Service in the United States, and doing data mismatch inaccuracies, and then having requests and requirements to respond to those type of issues is something that's very important to be prepared for. I think it's unlikely that if you're working in a corporate services provider or an entity that handles a lot of registered office services, you will have been untouched by those types of briefings over the last number of years. Then the qualitative assessments of economic substance structures that are in place for any of the relevant entities conducting relevant activities, that's an ongoing exercise and something that the DITC, TIA are the competent authority for. And then breach notices, these issued to principals' points of contact. And an important note actually on this yesterday from the DITC was that the design of the principal point of contact system was to ensure that if the authority needed to reach someone, that they were in a position to reach them. What I've seen from an anecdotal perspective is that sometimes the party that was appointed to that role may have left the organization, and so then the DITC is required to actually issue the notices to the registered office directly, and then we receive them then and pass them along for clients. So it's if you are somebody that's operating in that reporting field, it's important that any appointed principal point of contacts are reachable by the authority. Otherwise, there'll be an additional administrative task on you or your teams to make sure that the parties receive those points. There are opportunities to remediate or to potentially dispute the factual accuracy. So in certain circumstances, these are data mismatches. And as we said, there were, I think, in the actual thousands rather than just 1,000 of these notices that issued. So there are certain cases where there are fact patterns that will allow clarification to be provided and then an indication given by the authority that the notice may be withdrawn. And then also the payment options are also on the breach notices. So those 2 pages contain a lot of information, and it depends on the severity of the breach as to what the amounts are. But I think suffice to say, I can leave that part there, but it is something that we act for our clients on an ongoing basis on, in addition to the CIMA engagement. But the DITC issues tend to be a lot shorter because they're down to net points, other than the comprehensive inspections which were trailed, and will be interesting to see those observed over the next number of years as the authority has the resources to carry them out.
Yeah, I think I think they call them comprehensive reviews. So
Yeah.
this is something, Comms mentioned the desk-based audits, but it sounded like I was also at the Compliance Association conference that DITC were at, and these sounded like something kind of much more detailed that they have in mind in terms of comprehensive review. So everything we said about inspections, CIMA inspections in terms of being prepared and responding and so on, absolutely aligns with if the DITC conduct this sort of inspection as well. A couple of other practical points they made. DITC is a bearing in mind it's a pretty small team. They do not answer the phone. They will not respond to telephone inquiries. They explain they're not geared up to respond to telephone inquiries. They don't have recording equipment or anything like that. So I know people get a breach notice, they sort of panic and say, well, can't you phone SEMA and can't we sort this out? Fred, that's not the way SEMA seem to operate. So
the DITC, and we'll just make sure we're not
I'm
mixing
sorry,
up.
not SEMA, DITC.
Yeah.
Yeah, my comments in relation to DITC. So yeah, the DITC are not geared up for phone calls, and that they mentioned so they will respond to emails, but stick to they're usually a couple of email contacts, the enforcement team, the compliance team.
Yeah.
They said only copy in, though, only respond to those people. Sometimes people will escalate to other names. They said, please don't do that. That just kind of hold things up. So just respond to the people who are in contact with. Basically, that was DITC's advice. So I'm merely
Yeah.
passing on.
And that is my lived experience as well, I can say, and I don't want to digress off into a DITC session, but my experience has been that where there is a fact pattern that aligns to not the breach notice not actually attaching, those issues can be resolved very quickly and efficiently over email. So the generic email inboxes that are listed on the breach notice or the penalty notice itself, those are the ones to communicate through. So I have certainly had quite a bit of experience on those over the last years. And albeit a lot of people like to do business over the phone, if they're not set up for it, then there's that's just not an option. Whereas I think the SEMA process, to bring it back to the rest of the information, does involve quite a bit of interactivity over the phone and through telephone conferences. And indeed, it's a fundamental part of the approach to have interactions in live meeting settings. And I think it can inform the authority as to the level of commitment of your entity when you do get the chance to engage with them and to ask questions and to make points and to clarify things. So I certainly have been on calls where, albeit I'm there in a note-taking capacity, it has been possible to just get 1 or 2 points clarified, which then can move something from a discrepancy into not being a discrepancy anymore, because I may have not correctly described it in how I was trying to get it across. So it is something that has been very useful to me as a practitioner in engaging with the authority and getting to speak to people face to face. And it's very much appreciated that the regulator is open to that type of communication. And indeed, as I said, is part of the entire process.
Thank you. That was great information. I'm sitting here just taking tons of notes. Thank you, guys. And last slide here, and you can help. You're there in Cayman and able to provide some assistance. Did you want to speak on this, Com?
Yeah, sure. We're very, very happy to help, and having people that have practiced in this area exclusively for their entire careers, I think is probably what would set us apart. Ian, as mentioned, was the head of enforcement for the FCA, has an extensive experience in private practice as well. I myself have 2.5 years as a KPMG, worked in-house, and then have been in private practice for a number of years, but all working in either on your side of the fence as a compliance person, stroke legal counsel and a fund administrator, or indeed actually advising clients specifically on these type of items. So it's something that we live and breathe every day. I'm fortunate enough that there are 4 partners in the Cayman. There are 5 partners in the Cayman office, but I have 4 partners where we can socialize information and have very useful discussions to make sure that the best elements of all of our experiences are combined, because we do have a very good mix of actual trial lawyer experience, the in-house regulator consultancy, and everything in between. And so it does end up having a very solid and grounded approach, because we're sense checking our own views on things internally to distill down the messaging. But I think the list is there as to how we can assist. We have proactive products available in all these areas. We can also provide assistance in respect of the audit stream if that's something you wanted to do. And as I said, this is what we live and breathe every day. And so interacting with CIMA is something that's fundamentally important to our practice area. And so the maintenance of good relations with CIMA is something that we have prided ourselves on. And I will say, in tribute to the founder of our group, Lucy Frew, who has been the longest on island regulatory partner and now heads the largest offshore regulatory team of lawyers in the world. So, Ian, if you want
Yeah,
to.
I think it's coming back to the point I made earlier, is that, I mean, for most of you firms, this is going to be the first time you face this inspection. So, whereas obviously for us, we've seen a lot of these, we've got a very good view across the market, we have a good understanding of how the regulators operate and how best to respond. So to kind of take a medical analogy, if you're having an operation done, you wouldn't want a first-time surgeon removing your appendix or something like that. You'd want someone who's quite experienced and has done this before, kind of thing. So I hope we'd be able to help you from that perspective.
Yes.
Thank you. Okay, so we're going to move into questions, and I can see that we've got a few posed here. So let's see what I can find. Say, somebody said, as a small TCSP firm, will regulatory inspections carry enforcement actions or guidance for the next time for inspections?
So is the question, having been under inspection, will there be, I mean, I think there's several points here. Obviously, if you face an inspection, you'll be expected to carry out the remedial action. So from an individual firm basis, yeah, obviously if you're inspected again, then CIMA will come along and make sure we expect you to have carried that out. But also, CIMA very helpfully does provide feedback generally on inspections it carries out on an annual basis. And I think, the slide that Colm spoke to in terms of important themes is a kind of distillation of that. So CIMA is very helpful in terms of providing feedback annually on what it's seeing in inspections. But I mean, if the question is, if I'm a small firm, am I going to get inspected? Well, yes, you might be, and it's obviously appropriate to apply a risk-based approach, for example, in relation to AML as a smaller firm, but that doesn't mean not undertaking compliance. And just because you're a smaller firm doesn't mean CIMA are not going to expect you to comply with regulatory standards. So it's not kind of, oh, I'm a small firm, will they be more lenient on me? No, don't expect you to carry out standards, don't expect a smaller firm to undertake.
Yeah, I think the law applies mutatis mutandis, right? So it doesn't matter whether you're an enormous entity or otherwise, but Ian's point then on the risk assessment is critical. And I think actually what might be instructive in regard to the not closing out issues that had previously been identified, and at that point, if you go and look at the enforcement actions that have been taken, I think that would be very instructive to give you an answer to that question as to how important it is.
Okay. Yeah. And somebody does ask, and I think the answer is no to this. They're asking, do CIMA interview administrative staff, or do they limit it to just officers, management, and of course, your compliance staff and directors?
I think it would depend on the circumstances and to the role that was being discharged, because the oftentimes the person who's actually conducting the sanctions activity or that's responsible for the client onboarding will be the appropriate person to demonstrate that system. So it's kind of difficult to answer because the word administrator means different things within different organizations. But for instance, if you have a registered person that has an outsourced AML officer, oftentimes the procedures element of the AML requirements are retained in-house. And then that might be the internal compliance officer who's actually responsible for customer onboarding. And in that case, their job title could be administrator, and they would be expected to run through with the inspections team how the system works. So the answer is maybe, which was a very lawyerly way of answering a question for 2 minutes and then saying maybe at the end. But
yeah, I think I'd add to that from a purely, again, from a practical perspective. If CIMA literally are on site in your firm's offices, then yes, they are going to focus on interviewing the senior management and the AML staff. But and the compliance staff, but you're still going to want to project a kind of positive compliance image and have a fairly neat looking office and so on. It's kind of like, if SEMA coming on inspection, you kind of want people to kind of be aware of that. And I know certainly from working at the UK regulator, they might have a tendency, I'm not saying SEMA will do this, but will have a tendency to wander around just talking more casually to sort of more junior staff who might be actually being a bit more willing to disclose things that you might not want, informally you might not want to disclose. So I think you just want to be aware, if SEMA are actually coming to your offices, it's kind of common sense. You want to project a kind of positive and compliance focused image across the shop, really, and everyone needs to be aware of that, not just the senior staff, but more junior staff and your admin team as well.
Yeah, I actually have a situation, or it's not a situation, but
Yeah,
I
and
have
it's not to
seen
be.
common. Sorry, go ahead, Com. Oh,
I was just going to say it's nothing to be particularly afraid about. We're not talking about you're going to be that there's necessarily an downside from engaging with the team either. I think
No.
it's very, very important to say that this is not a scary process, and it's all very manageable because you will be well prepared by the time that any interaction is to be had. I just want to reiterate that. I don't want to hand this up as being something that's like the worst interaction that you're ever going to have with anybody. I've never had that experience in any of my dealings with the authority either. But again,
okay.
easy for us to say because this is what we do on a daily basis. Sorry for cutting across you, Kimberly. I think I actually
That,
broke up a little bit as well.
yeah, no, that's okay. And I was going to ask because I have seen the situation where like screening this is some larger firms where the screening is done by headquarters outside of Cayman, as an example. Would they ever perhaps want to talk
Yeah.
to the person who is doing those reviews, even though they are located in London or Luxembourg or something like that?
I think they've got full oversight of and can ask to speak to whomever they want. Like the authority has full discretion to require anybody to actually produce information and obviously if it's somebody is actually executing that work, then they are the right person to speak to because there's no point in getting the managing director in to walk through a sanction screening process when they've never actually looked at it and wouldn't be expected to. They just if we're looking at it on a waterfall basis, the board of directors and senior management are ultimately responsible, but I'm pretty sure nobody thinks that they're actually doing every component of every job. So it is certainly the case that SEMA have attended in offices overseas where required. So it definitely is the answer there, Kimberly, particularly for bigger outfits that do outsource things within the group, because intra-group outsourcing is a real factor. And it's a natural feature of regulated financial services because of the global nature of what we do. If you think about it, the products and services that we are offering from the Cayman Islands are consumed massively and across an enormous geography. It's why there are presences from the leading and the largest rather than the leading even. The firms, they all have presence in Asia and in the Middle East and in London as well, because that's where the clients are. And so it makes sense then if there are centralized functions that they need to be equally prepared.
Okay. One last question. When using external audit offices to conduct inspections, are NDAs signed, or how does SEMA guarantee confidentiality and/or conflict of interest?
From whom? I don't really understand the
I
question.
I'm assuming that it was mentioned earlier that you might have an accounting firm who comes in and does the audit.
Oh, yeah. So I'd actually have to defer to the authority as to the arrangements that are put in place
Okay.
with those
Yeah,
third-party firms. That's not something we can opine on. That would
yeah. I
be a
mean,
question.
I'd be fairly sure that they would work, obviously, as I said, under the instructions
Yeah,
of SEMA, and would be required to comply with the security standards of SEMA. But obviously,
yeah,
that's between the third party and SEMA. But
yeah.
clearly, confidentiality would be very important.
Okay.
And
Great.
all information is directed towards the authority. It's essentially somebody that's assisting under the supervision of SEMA, as you said. Sorry, I realize we're up to the line.
Yep, we are. So thank you again, Colm and Ian. If anybody does want to reach out to you, your emails and phone numbers are here. Do you prefer emails or calls?
Yep.
I like client requests on any form, Kimberly.
Okay, all right, fantastic.
Happy to deal
I'm
with either.
yeah, I'm
Thank you
sure.
everyone for attending.
Just
It's very much
yeah.
appreciated when it's going to be such a busy news and weather day. So thank you everyone for attending
It
and
is.
listening to
Yes.
us.
And just so you know, we had almost 400 people listening in. So with all that bad weather and of course the elections going on, that you brought in an audience. That's fantastic. Um, so yes, so thank you very much. And again, I'm getting a lot of thumbs ups,
Thanks
emojis
everyone.
here. I don't know if you can see that. So thank you again.
Yeah.
So again, for those of you, we are having hosting a workshop on Thursday. It's practical uses for ChatGPT safely, when not to use it, and how to use it. We also, for our Silo users, and even if you're not a Silo user, if you are wanting to be, or if you just want to know a bit more about Silo, we are starting a Silo certified user program. We'll be going into deep dives. These will all be about 1 hour each. Sorry, I don't know why my slides are doing these. And so it'll be 10 sessions. So we will start on Wednesday, the 13th, and get you very well versed in how to use Silo and how it works. And our next webinar, I don't know if anybody here saw the CBS 60 Minutes. It was broadcast in January 2024, and it was on Interpol abuses. And I remember watching it and thinking it was absolutely fascinating. Well, we have one of those expert guests that was on that 60-minute show. He is going to be with us the 27th of November. Ben Keith, he's going to be talking about Interpol abuses. It is frightening to hear how Interpol abuses can just destroy lives. So watch that. If you can look it up, I'm sure you can look up the actual 60 Minutes broadcast. You'll see Ben, and he will be with us on the 27th of November again for our final AML Gray Matters broadcast of 2024. And I hope everyone can join us then. So again, Colm and Ian, thank you so much. I think I have one more slide with your emails. And if anybody would like more information about Silo, Tom Gardner, there's his email as well. And again, Ian, Colm, I hope you will join us again in 2025.
We hope so. Thank you very much indeed.
All
Thank
right.
you very much.
Thank you.
Cheers. Bye
Okay.
bye. Have
Bye.
a great day, everyone.
Bye. Bye.